Good morning, Mr. Registrar. Could you call the case, please?
Good morning, Your Honors. Good morning to everyone in and around the courtroom. This is case number IT-0588T, the prosecutor versus Popović et al. Thank you.
Thank you. All the accused are here, and the presentation is exactly as it was yesterday, except for some legal assistance. Mr. Bougon? Good morning to you.
Good morning, Mr. President. Good morning, judges. Good morning to all my colleagues in the courtroom. On the screen before you, if you press the button for e-court, you see the boring figure which I was referring to yesterday. Surprisingly, when she failed to appear on the screen yesterday, because I forgot to ask the registrar to press on the e-court button, nobody reacted. So I take it that everyone was concentrating too much on what I had to say. In any event, what I said yesterday, Mr. President, is that whether you see the old lady with the sad look and her chin in the lower part of the picture, or whether you see the young lady with her fur coat and looking to the rear, what does matter is that if you put your mind to it, you will see the second lady in this picture, and she will reveal herself to you. Well, the same goes for the prosecution's case. If you put your mind to it, and I'm sure you will, and you disregard all of the unreliable evidence, which cannot be attributed any probative value, it will become clear to you that the prosecution failed to prove its case against Drago Nikolic. That being said, Mr. President, it has become clear to me, based on the number of pages I covered yesterday in 50 minutes, that I will simply not be able to cover all the material my team and I had prepared. So I have no choice but to skip many topics, and I'll try to focus solely on what is indispensable. These are the topics I will cover today, and they appear on the screen before you. My colleague will then conclude our closing arguments by addressing the trial chamber in respect of character evidence and sentencing considerations. If I can move in private session, Mr. President, please.
Let's move into private session, please. We are in open session.
Thank you, Mr. President. Next on my list is Momir Nikolic. I refer the trial chamber to paragraphs 589 to 646 in the Nikolic final trial brief. Our submission concerning Momir Nikolic is that no probative value can be attributed to his testimony that he visited the Zvornik Brigade Command and the Zvornik Brigade EKM in the evening of 13 July 1995. Despite the fact that Momir Nikolic has become another professional witness who knows his narrative by heart and who has been repeating it in many trials, when testifying before this courtroom, before this trial chamber, he made at least two obvious factual mistakes. He stated that when he arrived at the Zvornik Brigade on 13 July in the evening, he parked his car outside. He came in by foot. He identified himself as Momir Nikolic. He said he wanted to see Drago Nikolic. And he said he was the security organ of the Bratunas Brigade. All of this, Mr. President, is not something which witness Jeremic could miss. Jeremic actually confirmed in his statement, that is 3D 587, that it simply did not take place. Significantly, the prosecution did not challenge the statement which was admitted pursuant to Rule 92 bis. Another significant mistake made by Momir Nikolic is when he testified that he did not go in the EKM when he allegedly spoke to Drago Nikolic, whereas he testified to the contrary in the Blagojevic trial. Transcript 33251, 33525. Again, this is something he could not forget. It is evident that Momir Nikolic was but attempting to shape his testimony to avoid answering questions that he would not be able to answer concerning the Zvolnik Brigade EKM because he never went there. Next slide, please. Such mistakes, considered along with our detailed arguments, demonstrate that his testimony regarding this alleged visit cannot be attributed any weight. That being said, Mr. President, there are parts of his testimony which must be attributed some weight. One such issue is the following. Momir Nikolic testified about the chaos and the improvisation in Bratunac on the night of 13 July, when orders and counter-orders were being issued by the minute concerning the prisoners. Transcript 33233, 33234. This is significant as it illustrates the lack of any existing plan as to what was going to happen to the prisoners, at least up to that point. Next slide, please. Next on my list is Vinko Pandurević. Nikolic final trial brief 956 to 1015. As a preliminary matter, I wish to state for the record that our submissions are not related in any way to the alleged responsibility of Vinko Pandurević for the events of July 1995. This is way beyond our purpose. However, insofar as we are convinced that Vinko Pandurević did not tell the truth when he testified before this trial chamber, and that this testimony directly affected the situation of our client in this case, then this cannot be ignored. It is our position that the evidence he provided concerning his alleged meeting with Dragan Obrenović on 16 July at the EKM, during which Obrenović would have informed him for the first time about the presence of prisoners in the area of Zvolnik, and his knowledge of their fate cannot be attributed any probative value. The evidence reveals that Pandurević was informed of the details of the prisoner situation by Obrenović, whether at the Zvolnik Brigade Command or at the EKM, or in both places, as of 15 July 1995. What is most important is that Pandurević was informed of this situation before 16 July. When Pandurević was informed by Obrenović of the details of the prisoner's situation, it is our submission, Mr. President, that Obrenović did not tell him that he obtained this information from Drago Nikolic. Had Pandurević been informed that Obrenović obtained this information from Drago Nikolic, he would necessarily have engaged Nikolic on this matter, exactly as he testified that he would have expected Obrenović to confirm the order he was allegedly informed of by Drago Nikolic. Quite to the contrary, Pandurević confirmed that he did not speak to Drago Nikolic on 15 July. Transcript 31513. More importantly, when Pandurević reacted to the detailed information he received from Obrenović on 15 July, that's when he sent his interim combat report, he did not involve Drago Nikolic, who was the Zvolnik Brigade duty officer, in any way. Transcript 31585, 31586. Pandurević would have contacted Drago Nikolic if he had been involved in the way Obrenović suggested. This confirms that Drago Nikolic was no more than a minor player in these events. Lastly, we also fully agree with the prosecution's submission that the theory put forward by Pandurević that he did not exercise effective control over all elements of the Zvolnik Brigade when returning to Zvolnik on 15 July makes no sense. The evidence speaks for itself on this issue. A quick word must be said also about Pandurević, who made it very clear how much he disliked the security branch in general, as well as Drago Nikolic in particular. Why? Because of the information that Drago Nikolic would have reported about him. The fact of the matter is, Mr. President, that this apparent conflict, if I may use this word, between Pandurevic and Drago Nikolic is unrelated to the events of July 1995. Next slide, please. Next on my list is PW 101. For the reasons set out in our brief, paragraphs 845 to 891, it is our submission that the evidence provided by this witness cannot be attached any weight. The evidence reveals that PW 101 did go to Orovac in the evening of 14 July, but he was never ordered by Sreten Milosevic to take food to the execution site, and he never went there. In light of the detailed submissions presented by my colleague Zivanovic on Monday, transcript 34372, 34377, there's no need for me to add anything else concerning this witness. PW 101 clearly had a reason to provide such information to the prosecution, and his testimony must be disregarded entirely. Next, Srećko Achimović. For all the reasons set out in our final trial briefs, paragraphs 892 to 955, it is our submission that the entire testimony of this witness cannot be given any weight whatsoever. My colleagues stated, and I quote, that is the prosecution, that Achimović is guilty and that he was in this up to his eyeballs. Transcript 34254. On this basis alone, his testimony should be set aside entirely. Time being of the essence, I move to the next witness. Witnesses PW 102 and PW 108. I refer the trial chamber to paragraph 699 to 844 of the Nikolic final trial brief. It is our submission that the evidence provided by these two witnesses cannot be attached any probative value. Significantly, the prosecution briefs speaks for itself concerning the weight to be given to this evidence. 4 paragraphs, 2730 to 2733. In fact, it really appears as though the prosecution decided to rely on the evidence of these two witnesses, knowing that it was not worthy of belief, with the aim of keeping the defense team of Drago Nikolic busy. Well, that strategy worked, I can tell you that, Mr. President. Anything to salvage the testimony of PW 168. In the end, however, on the basis of our detailed arguments, there can be no doubt that the alleged visit of these witnesses to the Zvolnik Brigade Command on 14 July never took place. I note that the prosecution concurs that this visit could only have taken place on 14 July, which is one of the reasons why it simply cannot have taken place. I also take this opportunity to underscore the link between the narrative of witness PW 168 and the evidence provided by PW 102 and PW 108. We take the view that this is yet another indication of the lack of credibility of witness PW 168. Lastly, I turn to Mihailo Galic. In the Nikolic final trial brief, paragraphs 647 to 698, it is our submission that no weight can be attributed to his testimony that he replaced Drago Nikolic at the EKM in the evening of 13 July. In its final trial brief, the prosecution challenged the credibility of witness Dragan Stojkic, as well as the defense assertion that the EKM Operation Duty Officer logbook was tampered with. As for witness Stojkic, his testimony regarding the time he spent with Tactical Group 1 and his return to the Zvolnik Brigade is plausible and can be reconciled with the testimony of Yevdevich and Dragutinovich, whom the prosecution does not believe, I hasten to add. Stojkic may have been mistaken concerning the location where he spent the nights of 11 and 12 July after Tactical Group 1 had entered Srebrenica. But there is no evidence contradicting his testimony that he was with the tank company that returned to Zvolnik on 13 July. Using the standard which the prosecution would like you to use in rejecting the testimony of Stojkic, this would result in the testimony of most witnesses in this case being rejected. Turning to the EKM logbook, the prosecution fails to understand our arguments set out at paragraphs 680 to 697 of our final trial brief. Simply put, Mr. President, our submission is that the reason why the EKM duty officer logbook is indeed perfect regarding the number of pages in the book, regarding the numbering of the pages, regarding the stamp at the end with Obrinovich's signature on it certifying the number of pages, is precisely because it was tampered with. The EKM logbook is the only one of its category which was not transferred to the 5th Corps along with the Zvolnik Brigade archives before the prosecution conducting its search of those premises. This is not a coincidence. Obrinovich kept this book because it was part of his defense and he wanted the prosecution to have it. One last observation needs to be made in this regard, which is simply that if you look at this book, and if you look at the other entries made by Drago Nikolic in other books, it is simply not possible that the EKM that when Drago Nikolic was at the EKM on 13 July, which is undisputed, that he made no entry whatsoever in this book. Where did these entries go? Answering the question, asking the question is providing the answer. Before moving on to my next topic, I take this opportunity to quickly address the evidence of witnesses PW143, Lazan Ristich, and I think it's 3D1, but it's a witness who testified in closed session. Regarding PW143, we did not make any submission concerning his credibility in the Nikolic final trial brief. To put it simply, his testimony was so equivocal concerning the presence of Drago Nikolic at the Zvolnik Brigade Command and at the school in Oraovac in the evening of 13 July that it simply cannot be attributed anyway. I take this opportunity to add that it is our respectful submission that the questions put to him in redirect examination were impermissible. I refer you to Archbold 2006, page 394. Moving on to prosecution Lazar Ristich. Prosecution suddenly argues something which my colleague repeated during his oral argument, transcript 34254, that he was a major player along with members of his battalion, the 4th Battalion, in the executions which took place in Oraovac. This is not what the evidence reveals. This was never suggested during the testimony of Lazar Ristich before this trial chamber. I note in this regard that when he testified, the prosecution did not even request that Lazar Ristich be given a Rule 90 echo warning. The only reason for the prosecution's unfair and inappropriate submission is that the evidence of Lazar Ristich establishes clearly that information provided to him by witness PW168 is a complete fabrication. We can go in private session, Mr. President, please.
Let's go into private session, please, for a short while.
I immediately move on to my next topic, which is the missing evidence in this record. My colleague Stojic has underscored the fact that the prosecution refrained from calling many witnesses whose testimony was critical in order to fully establish what really happened in July 1995. I join his submission and I draw the trial chamber's attention to the following witnesses who should have been called by the prosecution. In particular, we respectfully submit, considering that the trial chamber met with Jesse Kovacs, the commander of the military police company, that it is unacceptable that he was not called by the prosecution. Even though Jesse Kovacs refused to meet with the defense, we are convinced that his testimony could have allowed to confirm that Obrenović is the one who personally received the information concerning the impending arrival of prisoners in the area of Zvornik, that Drago Nikolic was not contacted regarding this, and that Obrenović is the one who issued the orders to Jesse Kovacs to deploy to Oraovac with some members of the military police company. Members who, by the way, were not hors de combat or unfit for combat.
Excuse me, I'm sorry to interrupt, but I don't, the suggestion that the trial chamber met with Jasikovac, I'm not sure that's what you mean to say, and that I'm not sure should be in the record. Line 16.
I thank my colleague for this. I was talking about the prosecution who met with Jasikovac. There was never any way that the trial chamber would meet with Jasikovac.
Thank you, both of you. Thank you particularly, Mr. McCloskey, for it.
As for Dragomir Vasic, he could have confirmed that Obrenović never met with Jokic at Standard on the morning of 15 July. He could also have confirmed that Momir Nikolic was not privy to the alleged conversation between Deronic and Beara on the night of 13 July. Lastly, considering that the prosecution has withdrawn witnesses Salapura and Golic from its Rule 65 third list of witnesses, it is our submission that it cannot rely on entries in the Zvornik Brigade Operations Duty Officer Notebook involving Salapura and Golic to infer that Drago Nikolic worked closely with Beara and Popović during the period from 13 to 16 July. This is not what the evidence reveals. After 14 July, Drago Nikolic clearly kept away from everything that was happening. Clearly, the prosecution has never been interested in establishing the true involvement of Drago Nikolic in these events. I move to my next topic, the first joint criminal enterprise alleged by the prosecution, forcible transfer. There are two preliminary issues I must deal with, namely the victims who were supposedly forced out the Srebrenica and Jepa enclaves, and the prosecution's burden of proof pursuant to the GCE mode of liability. Regarding the victims of forcible transfer, this is an issue that arose during the presentation of arguments pursuant to Rule 98 bis. The trial chamber decided at that time that this was an issue best left to be determined at the final stage of the trial. Our position, set out in detail in the Nikolic final trial brief, is the following. The men who were separated from the crowd in Potocari were detained and transported to Bratunac, and the men who voluntarily left the Srebrenica enclave, only to be later captured as part of the column heading towards Tuzla, and who were then transported to Bratunac, both of these categories of men were not victims of forcible transfer. Prosecution argues that these men were part of the Muslim population and that they were the victims of forcible transfer because they were lawfully present in Srebrenica. Prosecution also suggests that these men did not exercise a genuine choice to leave the enclave and that they did so in order to escape the VRS attack on the enclave. That is paragraph 2897 of the prosecution's brief. The prosecution's arguments are erroneous both in law and in fact. Without repeating all of our arguments, Firstly, what the prosecution omits to consider is that in addition to the legal status of the man, an issue which we argue in our brief, what matters is what the alleged perpetrators intended to do with these men and the manner in which they were treated. Looking at the men who were separated from the women, children, and elderly in Popović, it is evident that they were separated because the VRS intended to do something different with them that they were not doing with the women, children, and elderly. The aim may have been or may not have been to forcibly transfer the women, children, and elderly. Not so for the men, however. If, as the prosecution alleges, the decision to kill these men had already been taken, which is a conclusion we dispute, of course, then it was not forcible transfer. The crime envisaged was murder. On the other hand, if the decision had not been taken to kill these men, which is the conclusion we say the evidence supports, again, detaining men who allegedly participated in hostilities, to screen them and to treat them as prisoners with a view to using them for a future exchange is not forcible transfer. The prosecution argues that the VRS did not view them as prisoners because they were not distinguishable as soldiers. Paragraph 2907 of their brief. It is necessary to recall, as I did yesterday, that this was a non-international armed conflict, that these were men of fighting age, and that they were detained because of their suspected participation in hostilities against the VRS. The prosecution also says that these men were denied food and water, and that some were beaten, which implies that the VRS did not view them as prisoners. Of course, depriving prisoners of food and water and mistreating them, if that was established, is a violation of international humanitarian law. But it does not change the fact that these men were detained and were in the hands of the VRS at the time until it would be decided what to do with them. That is not forcible transfer. The fact that they were prisoners in the hands of the VRS allowed the VRS to transport them legitimately as prisoners to detention facilities, again, which is not forcible transfer. What about the man who left with the column? Well, the most important consideration here is the fact that they left Srebrenica voluntarily. The evidence reveals that this was an organized withdrawal, the aim of which was for the members of the 28th Division and other men of fighting age to reach Tuzla, where they could assist the 2nd Corps of the ABIH in future combat operations. Contrary to the prosecution's argument, these men were not forced to leave the Srebrenica enclave. The VRS had not even reached Srebrenica when the column started on its way to Tuzla. Popović explained during his testimony that the 28th Division was retreating faster than he was advancing with Tactical Group 1. They weren't retreating, they were on their way to Tuzla already. Moreover, these men had the option at that time to surrender. The reference for Popović in here was 30867, 30868. These men had the option to surrender. There was at that time no prospects that they would be the object of criminal acts if they surrendered. Moreover, once the VRS realized that these men had left Srebrenica and that they were on their way to Tuzla, their immediate reaction was to intercept these men and to prevent them from reaching Tuzla, which shows that the VRS did not have forcible transfer in mind. If forcible transfer is what the VRS had in mind, they would have simply let the men reach Tuzla. Furthermore, once these men were captured along the road leading towards Konievish-Polier, the same reasoning applies as for the men who were separated in Popović. If it was already decided to kill them, then, which is not supported by the evidence in our view, then it was not forcible transfer, it was murder. If the decision had not been made to kill these men, which is what we say the evidence supports, again, detaining men who allegedly participated in hostilities and who are attempting to link up with their own forces and transporting them to Bratunac and ultimately to Zvornik is not forcible transfer. Consequently, it is evident on the basis of the evidence on the record that the men who were captured when traveling with the column and the men who were separated were not forcibly transferred out of Srebrenica. What about the men from Žepa? Time being of the essence, I will not address this issue, although I would be glad to answer any questions on this topic. It follows, Mr. President, that the men who were separated in Popović and the men who left Srebrenica with the column were not forcibly transferred.
Sorry to interrupt you, but perhaps while you are still on forcible transfer, you could address the question of when this crime is consummated, is executed, is completed, in other words. In other words, whether arrival at a particular destination is required, or whether it is completed at the same time that the persons are forcibly removed from where is their habitual residence.
Thank you, Mr. President. The moment that the VRS detained the men who were separated from the crowd in Popović, the crime which started then, if there was a crime, is detention or murder, or no crime at all, and it was not forcible transfer. As for the men from the column, the moment they left Srebrenica voluntarily, there was no forcible transfer. Thank you, Mr. President. As will be argued later, even if the trial chamber would hold that these men were victims of forcible transfer, then there could be no doubt that the result would be the same for Drago Nikolic. Moving on to the second preliminary issue. The following are the essential elements of a GCE as a mode of liability. This is what the prosecution must prove. First of all, of course, the mens rea, and that is on the screen before you. The intent to achieve the common purpose. Prosecution must prove the applicable mens rea, must determine the applicable mens rea for each of the crimes the common purpose involves. This includes proof of any specific mental element required, such as the chapeau requirement for crimes against humanity. Prosecution must establish also that the components of the mens rea, that the mens rea for each of the crime has been established. If the prosecution fails to prove any of these elements, then the accused is not a member of the joint criminal enterprise, in which case the criminal responsibility of the accused must be assessed pursuant to other modes of liability under Article 7.1 of the statute. This is what we argue in the case of both GCEs for Drago Nikolic. Drago Nikolic did not have the required mens rea, which implies that he was not a member of the two alleged GCEs. At his level, he never got the information about the two GCEs, and he was never a member. That is why his responsibility must be assessed pursuant to other modes of liability included in Article 7.1 of the statute. Second, of course, the prosecution must prove the actus reus, which requires proof beyond reasonable doubt that the accused significantly contributed to the accomplishment of the common purpose. Taking a closer look at the mens rea requirement for GCE, these are the steps on the screen before you which must be followed in order to determine whether the prosecution has met its burden of proof. First, the common purpose must be identified precisely. Then, it must be proved that the accused knew the common purpose. Third, it must be established beyond a reasonable doubt that the accused intended to further the common purpose. The mens rea for each crime must be identified. And it must be proved beyond a reasonable doubt that the accused had the required mens rea for each of these crimes. Prosecution uses the GC mode of liability against Drago Nikolic. It's very clear why. He's only in Oravats, but he's guilty for everything. Because by significantly contributing to one of the execution sites, then he can be found guilty of all of them. But the prosecution omits to consider that for this to happen, he must be a member of the GCE. And being a member of the GCE imposes on the prosecution a very high threshold of proving beyond a reasonable doubt that Drago Nikolic had this mens rea, that he was in the planning, in the creation of this GCE. And in order for him to accept the GCE later on down the line, he must still know what the GCE is. He must intend to further that common purpose. Drago Nikolic never had this intention, never had this detailed knowledge. As argued in the Nikolic final trial brief, the common purpose of the GCE alleged by the prosecution, the first GCE, chronologically, is the following: to force the Muslim population out of the Srebrenica and Jepa enclaves to areas outside the control of the RS from about 8 March to the end of August 1995. Paragraph 49 of the indictment. The word "end," which is underlined, is important. The GCE alleged by the prosecution includes both Srebrenica and Jepa. Even though the trial chamber previously held that whether there was one or two GCEs related to the forcible transfer of the Muslim population from Srebrenica and Jepa, trial chamber said that this was a matter for evidence at trial. We respectfully submit at this stage, it is not open, Mr. President, to the trial chamber to modify the common purpose of the GCE as alleged by the prosecution in the indictment. In any event, even if the trial chamber was to split Jepa and Srebrenica in terms of making two GCEs, the result will be the same. Moving on, Mr. President, we respectfully submit that the prosecution's allegation that the Muslim population was to be forced out to areas outside the control of the VRS must also be proved. The prosecution claims that this is not an element of the crime. That's irrelevant. Of course it's an element of the crime. But, as the prosecution concedes, it's an element which defines the common purpose of the alleged joint criminal enterprise. And if it defines the common purpose, then of course the accused must be aware of the common purpose, and he must intend to further the common purpose, which includes the transfer to areas outside the control of the RS. It is our submission that Drago Nikolic was not aware of the common purpose of this alleged GCE and that he never intended to further the common purpose. Well, let's take a look at Srebrenica enclave. Clearly, Mr. President, the evidence reveals that Drago Nikolic was never informed of the common purpose to force out the Muslim population composed of the women, children, and elderly who went from Srebrenica to Potocari, from the Srebrenica enclave to areas outside the control of the RS. This was argued in our brief at paragraphs 1027 to 1043. Significantly, the prosecution agrees with this submission, at least for two reasons. First, they do not counter our submission that Drago Nikolic was never informed of the common purpose to force out the Muslim women, children, and elderly. Second, looking at paragraphs 2785 to 2787, the prosecution refers specifically to the knowledge of Drago Nikolic concerning the prisoners or the men from Bratunac. Never is anything mentioned about the women, children, and elderly in Popović. Accordingly, if we are right in saying that only the Muslim women, children, and elderly were forcibly transferred, then the only conclusion is that Drago Nikolic did not have knowledge of this common purpose to force them out of the Srebrenica enclave. Due to time constraints, I will not address the Jepa enclave, which is addressed in our brief. Let me recall, the only conclusion then, Mr. President, is that the required mens rea to be a member of the GCE has not been proved beyond reasonable doubt. Therefore, Drago Nikolic was not a member of that GCE. As mentioned earlier, this is of the utmost importance in considering the criminal responsibility of Drago Nikolic in relation to all the events which took place in the Srebrenica area in July 1995 and the related allegations in the indictment. Obviously, if Drago Nikolic was not a member of the GC to forcibly transfer the Muslim population, this establishes a clear difference between Drago Nikolic and any person found to be a member of this GCE. Moving on, Mr. President, because we say he's not a member, it's not necessary to address the mens rea applicable to the crimes included in the GCE, but I would be glad to answer any questions on this issue. It's not necessary either to address whether he significantly contributed to this GCE, but I will not address this issue either, but I'll be glad to answer any questions. The only possible conclusion, because he was not a member, that there's no evidence and the prosecution has failed to prove, that Drago Nikolic incurs responsibility pursuant to either the JCE mode of liability or other modes of liability included under Article 7.1 of the statute. He was not involved in any way in forcing out the Muslim population from the Srebrenica and Jepa enclaves to areas outside the control of the RS. Now the question is, what if the trial chamber rules that the men from Bratunac, in respect of the Srebrenica enclave, and the military able population in relation to the Jepa enclave, if the trial chamber rules that they are included in the persons who were forcibly transferred and deported, it is our submission that the result is the same. There is no evidence that if and when Drago Nikolic was informed of the arrival of prisoners in the area of Zvornik, he knew that these men were anything but prisoners. In any event, he did not know that how these men ended up in Bratunac. He did not have information about the separation of men in Popović. He did not have information about men captured from the column. He did not have information how the men captured from the column were taken to Bratunac. The evidence reveals that what he knew after allegedly meeting with Beara and Popović on 14 July is that he was tasked with accommodating some people coming for exchange purposes, something he was not previously informed of, and there were no mention of killings. When the question was put to my colleague whether he could point to any evidence that Drago Nikolic was informed that the prisoners who arrived in the Zvornik area had been forced out of the Srebrenica enclave, he was not able to identify any relevant evidence on the record. Transcript 34264, 34268. As also argued in our brief, and as I said earlier, Mr. President, in response to your question, the crime of forcible transfer was over by the time these persons arrived in the Zvornik area. Also, with respect to the actus reus, it simply cannot be said that by directing the buses carrying these prisoners from the Hotel Vidikovac to one or more of the schools in Zvornik significantly contributed to forcing out these men out of the Srebrenica enclave to areas outside the control of the RS. It is also significant that these men were never transferred to areas outside the control of the RS, which, as mentioned earlier, is an allegation which the prosecution had to prove. As for the military men from the Jepa enclave, there is no evidence that Drago Nikolic was aware of the alleged crimes occurring in Jepa at the time, let alone that he ever intended to forcibly transfer these men to areas outside the control of the RS or to deport these men across a national border. For all of these reasons, Mr. President, Drago Nikolic must be acquitted of counts 7 and 8. I move to the second GCE alleged by the prosecution, starting once again with the identification of the precise common purpose. As argued in our final trial brief, the purpose of the GCE alleged by the prosecution is the following: to kill all the able-bodied men, Muslim men, from Srebrenica. The prosecution did not dispute this submission during its oral arguments. What is significant here, Mr. President, is the word all. The prosecution cannot argue that the indictment means or implies a different common purpose. As argued at length in our brief, paragraphs 1149 to 1204, the evidence reveals that Drago Nikolic never knew of, nor that he was ever informed about the common plan, design, or purpose to murder all the Muslim men or the able-bodied Muslim men from Srebrenica. The evidence adduced by the prosecution fails to prove otherwise. I draw your attention to paragraph 1160 of our final trial brief. Even if the statement of facts provided by Obrinović and or Momir Nikolic were given any weight, contrary to our submissions, DN would have learned, worst case scenario, of a crime about to be committed against a large number of prisoners about to be transported to the area of Zvornik. Drago Nikolic did not know, and it is not possible to infer that he knew how many prisoners were to be transported to Zvornik, nor that he knew how these men ended up to Bratunac. Moreover, considering that Drago Nikolic was the duty officer at the IKM until 14 July in the morning, it may possibly be inferred that he knew that a significant component of the 28th Division had already entered the area of Zvornik. Hence, when he was informed that prisoners were arriving, or...
Could counsel please slow down, please?
I apologize, thank you.
Okay, thank you.
When he was informed about the prisoners about to arrive in the Zvornik area, there's no way that he could assume that these prisoners represented all the men from Srebrenica. A large component were fighting in his own territory. It is our submission, Mr. President, that there is no evidence and that it cannot be inferred that Drago Nikolic was informed of the alleged common purpose to kill all the able-bodied men during the alleged meeting of 14 July when he supposedly met with Lubisha Beara and Vujadin Popović. There is no evidence that he was aware of the common purpose to kill all the able-bodied men before attending this meeting. Secondly, the evidence provided by Birchakovic about his conversation with Drago Nikolic as he was coming out of this alleged meeting is credible and must be accorded full weight. Hence, there is direct evidence on the record that during this meeting, Drago Nikolic was not informed about the killing of prisoners, let alone about the common purpose to kill all the able-bodied men from Srebrenica enclave. Moreover, even if Drago Nikolic would have been informed during this meeting that the prisoners about to arrive would be killed, this still falls short of the required knowledge of the common purpose for Drago to become a member of that joint criminal enterprise. It is necessary to recall that at that moment, Drago Nikolic knows that a significant number of able-bodied men from Srebrenica are fighting their way in the very area of Zvornik. And he may possibly have known that the orders coming from the main staff were to prevent these men from linking up with the Second Corps, not to kill them. The prosecution advances that Beara and Popović had no reason to lie to their fellow security officer by telling him that the prisoners were to be exchanged. Of course, we disagree with this proposition for many reasons. Firstly, even though Drago Nikolic was a security officer, and if such conversation ever took place, the prosecution appears to place on an equal footing Drago Nikolic with senior officers of a much higher level. Drago Nikolic was but a security officer of a brigade. He had the lowest possible rank for an officer. Hence, there would be no reason for Beara and Popović to share with Drago Nikolic the details of the common purpose, if it ever existed. What they would necessarily have been interested in would be giving instructions to Drago Nikolic as to what they expected of him, nothing more. That does not make Drago Nikolic a member of that JCE. Moreover, the prosecution's argument that Beara and Popović had no reason to lie can also apply to Drago Nikolic, who had no reason to lie to his fellow security officer, Slavko Peric, from the 1st Battalion, or to his driver, Birčeković. There is no evidence that Slavko Peric, Rajko Babic, Momir Pelemic ever received any information, whether from the telegram they allegedly received or from Drago Nikolic, that the prisoners were to be killed, let alone that the aim was to kill all able-bodied men from Srebrenica. Hence, the prosecution's submission implies that Birčeković lied, Babic lied, Peric lied, and or that Drago Nikolic lied to them. That's not supported by the evidence. Furthermore, even considering what the prosecution submits, Beara and Popović would have told Drago Nikolic during this meeting, this does not include information related to the common purpose of the alleged GCE, i.e., to kill all able-bodied men from Srebrenica. Lastly, the prosecution advances during this meeting that Drago Nikolic would have made proposals on suitable locations for detaining, executing, and burying the prisoners about to arrive. This allegation is unsupported by any evidence. The fact that Drago Nikolic was a security officer and that he may have been familiar with the area of Zvornik is insufficient in the absence of direct evidence as to what was actually discussed during this alleged meeting to infer that he was aware of the common purpose. The same goes for the fact that Drago Nikolic, for the fact that engineering equipment was deployed, or the fact that soon after this meeting, buses of prisoners arrive in the area of Zvornik. The ultimate question, Mr. President, is whether, on the basis of the evidence on the record, it can be inferred beyond a reasonable doubt that Drago Nikolic was informed by Beara and Popović of the common purpose of the alleged GCE to kill all the able-bodied men from Srebrenica. This question, Mr. President, must be answered in the negative, because simply there are other possibilities supported by the evidence. Then such an inference cannot be made. To mention but one such possibility, the evidence supports the inference that Drago Nikolic was called to attend a meeting with Beara and Popović at the Zvornik Brigade Command. That Drago Nikolic attended this meeting, during which he was informed of a number of prisoners about to arrive, and he was asked to accommodate them in schools previously identified, such as the Kula School. Considering that the 1st Battalion had already been informed by telegram of the arrival of prisoners, coming out of this meeting, Drago Nikolic picks up the phone, calls the security officer from the 1st Battalion to suggest to him, not to order him, but to suggest to him, whatever your commander decided, or whoever your commander decided to send to the Kula school, let's avoid any problems with the local population. You should go there because your house is located close to the school and you know the area. Then Drago Nikolic meets with his driver. He informs his driver of what he has been told during this meeting. He expresses his dissatisfaction without reserve, and they drive to Hotel Vidikovac, where sometime later the convoy of prisoners arrives. This scenario, Mr. President, is supported by the evidence in a much stronger way than the inference the prosecution would like you to draw. The inference the prosecution is asking you to draw is simply a bridge too far. That being said, we're not blind to the evidence, as I said yesterday. At some point, Drago Nikolic found out that prisoners taken to Oraovat school were being killed. That is a given. As argued in our final trial brief, this took place at the earliest when Drago Nikolic returned to the Oraovat school in the early evening, and from there drove to the IKM with his driver Birchakovic. For the purpose of his knowledge of the common purpose, however, even when Drago Nikolic found out that prisoners were being killed, what matters is that that did not provide him with the knowledge of the common purpose of the alleged GCE to kill all the able-bodied men from Srebrenica. This he never learned, and there is no evidence that he did. Not even when he was allegedly close to the Petkovsky school in the afternoon of 14 July, or when he saw 40 to 50 bodies driving by the water point with Birchakovic that night. The evidence provided, of course, by witness PW101, as mentioned earlier, cannot be attributed weight, and it simply cannot be concluded that Drago Nikolic was present at the execution site that night. In these circumstances, we respectfully submit that it must be concluded that he was not a member of the alleged GCE, the purpose of which was to kill all able-bodied men from Srebrenica. Does that mean that he was not involved in any way in what happened in Oraovat on 14 July? Of course not, Mr. President. I said that at the beginning of these closing arguments. The evidence reveals that Drago Nikolic was close enough to the events which took place in Oraovat to possibly incur some individual criminal responsibility. Consequently, I will now address the prosecution's arguments in part Roman 12 of the prosecution's final trial brief, the title of which is Individual Criminal Responsibility of Drago Nikolic under Article 7.1 of the statute. The best way to do this, Mr. President, is to refer to the overview of the prosecution's case against Drago Nikolic, found in section, I was supposed to make something funny here, CCX111 or III of the prosecution's final trial brief. I don't know who had the idea to use Roman numerals for these sections, but it was quite the feast to make my way through the prosecution's brief. At paragraph 2600, the prosecution submits that the involvement of Drago Nikolic in the murder operation began when he was contacted by Vujadin Popović and asked to make preparations for the prisoners.
I think you're going too fast, Mr. Bougon.
Thank you, Mr. President. I will slow down.
The recorder is not catching up with you.
I apologize. As argued by my colleague Zivanovic, and as explained earlier, it is our submission, Mr. President, that this telephone conversation between Popović and Drago Nikolic never took place. It follows that the very foundation of the alleged telephone conversation between Dragan Obrenović and Drago Nikolic is inexistent. Consequently, without the alleged information coming from Popović, there is no reason for Obrenović to call for Drago Nikolic to call Obrenović at that time. It is thus evident that this part of Obrenović's statement of facts is nothing but a fabrication. So Drago Nikolic, of course, if that conversation did not take place, was not authorized to leave his post at the IKM that evening, nor was he authorized to use Yesikovats and 5 or 6 MPs unfit for combat for the purpose of assisting Beara and Popović with the PWs. Moreover, the evidence reveals that Yesikovats is the one who gave the orders for MPs to go to Orovats. Stevo Kostic, transcript 26003. So how did this take place? Well, consider the following, Mr. President. There is no evidence that Yesikovats was in the field that night. It would have been illogical for Obrinović to withdraw the commander of the military police in the field at this critical time. The tactical intercept used by the prosecution, that is P2232, contains no reference to any conversation involving Yesikovats. If Obrinović had received instructions regarding Obrinović had received instructions regarding the detention of members captured from the column in the early afternoon, that is P45. Obrinović did not inform the duty officer Sreten Milosevic of what was going on. Drago Nikolic was at the IKM, and he was of no immediate assistance to Obrinović. Considering that the time at which Obrinović left the Zvornik Brigade command that night is after the time the military policeman would have left to Orovats, the logical conclusion, Mr. President, is that Obrinović must have received personally the information that a group of prisoners would be sent to Orovats. He never spoke to Drago Nikolic about this. He personally gave the order to Yesikovats to take the members of the military police who were available at Standard, not because they were unfit, but because that was their place of duty that night, to go to Orovats and prepare the school. In his statement of facts, Obrinović lied about the involvement of Drago Nikolic because the prosecution put pressure on him to fill in the gap in its evidence, and because, of course, admitting his true responsibility in these events would have meant a much higher sentence recommendation. The next allegation in the prosecution's overview is at paragraph 2601, that Drago Nikolic oversaw the deployment of MPs and the detention of prisoners who arrived at Orovats that night. And of course, prosecution says, knowing that they would be murdered, but I've dealt with that already. Strikingly, the prosecution...
Could the council kindly slow down? Thank you.
Thank you, I apologize. Once again, strikingly, the prosecution omitted in its overview the alleged visit of Momir Nikolic at the IKM that night. The reason for this is obvious. As mentioned in our brief, prosecution knows that Momir Nikolic lied, and before the trial chamber decided to call him as a witness in this case, they had given up on trying to rely on his evidence. There is no evidence, Mr. President, that Drago Nikolic was informed on 13 July that prisoners would be murdered in the Zvornik area. There is also no evidence that Drago Nikolic was at the Orovats school during the evening or night of 13 to 14 July. As mentioned earlier, the testimony of PW 143, the only one who would maybe have seen Drago Nikolic at the Orovats school, cannot be given any weight. Another missing element in the prosecution's overview is the alleged replacement of Drago Nikolic by Galic that night. It is significant in this regard that the prosecution did not prove or attempt to prove, for that matter, the whereabouts of Drago Nikolic that night if he had been replaced as the IKM, contrary to the evidence in our arguments. Moreover, the prosecution refers to the testimony of Birchakovic. The prosecution does not dispute the fact that he was ordered by Turbic to pick up Drago Nikolic at the IKM on the morning of 14 July. And that he did so. That's final brief of prosecution, paragraph 654, 655. If Birchakovic went to the IKM to pick up Drago Nikolic on 14 July in the morning, then where was Galich? These are powerful indicators that Drago Nikolic was never replaced at the IKM that night. Prosecution overview, paragraph 2602. The meeting with Beara and Popović. I've dealt with that already. The order to the 1st Battalion of the security officer of the 1st Battalion. That's 2603. I've dealt with that. Prosecution overview 2604. That the day of 14 July, Drago Nikolic oversaw the detention of prisoners at Oraovac. There's no evidence that he coordinated anything at Oraovac. The only witness who says this is PW 101, and his evidence is not worthy of belief. We have to consider the evidence provided by MPs about how many times Drago Nikolic was at Oraovac that day. Of course, the prosecution takes all the times that all the military policemen say that Drago Nikolic was there and concludes that he was there many times. It's just different times for those two events that have been proven. Drago Nikolic was there twice. More importantly, there is no evidence that the military police from the Zvonik Brigade blindfolded the prisoners and placed them on trucks. The evidence reveals that some members from the Bratunas Brigade came in. Prosecution did not even investigate that. We provided the prosecution with the indictment that exists against members of the Bratunas Brigade. That is 3D133. They never looked into that. They weren't interested in finding out who was blindfolding the prisoners, who was putting them on the truck. They weren't interested in that. They knew from the testimony of the victims that persons wearing red berets were involved in these events. Did they try and go and look to Bratunat's red beret? My colleague said it's a very famous unit who may have been involved in the executions. They did not look into that. Prosecution overview, paragraph 2607 or 2606, that Drago was present at the execution site. I've dealt with that already. 2607, he did not place any phone calls to Achimović. That's established, and I've dealt with that. 2608, now we get into pure speculation. An alleged meeting with between Drago Nikolic and Beara at the Zvonik Brigade Command on 15 July. Why?
Shall we deal with that after the break?
Indeed, Mr. President, we can do that.
Okay, thank you.
All rise. Veuillez vous lever.